what's a court going to consider whether there was good business judgment or there wasn't? Number one, the decision made by the directors or the officers must have been made in good faith. Number two, the decision needed to have been informed. Directors need to show that they gathered relevant facts, consulted with experts where appropriate decisions were made based upon good and reasonable judgment. And number three, the decision needs to be considered to be in the best interest of the corporation or the LLC. Even if the decision ultimately proved to be unwise, as long as it was made with reasonable care and without conflicts of interest, the court will generally defer to the board's judgment. This is a ruling that came out, Auerbach v. Bennett, in 1979, a Court of Appeals case where the business judgment rule really came into being. And it was done so because courts have always been very hesitant to allow shareholder claims to continue. It's a strong belief that corporations should be able to operate without the constant and consistent concern that there's going to be litigation over every single decision that they make. And yes, for those of you that are familiar with what's taking place in Delaware right now, there is a concern by many companies that shareholder opportunities have grown and grown, such to the point that these types of defenses have no longer the same merits in the Delaware court system. And now you have a scenario whereby officers and directors and companies generally are talking about leaving Delaware, and in fact many major companies have, to avoid these scenarios where shareholder emboldenment can no longer take advantage of the company's position. And that's why you're starting to see a lot of companies leave Delaware and go to other jurisdictions.